It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table. I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And
again, not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson. Okay.
And next page, actually go 2 page to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
Is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
no, you were right, 154. Yeah, this is one. What's the exhibit on this? Okay. You're familiar with this chart, right?
I've reviewed the first page of this chart. I have
Sure.
not reviewed the entire.
Go to the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STR Mix, the STAR Mix software, in order to perform an analysis of the software that looks at the possibilities for DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunetter's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that?
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness in her first
Right.
I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. A likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1 you say the profile is consistent with at least 4 contributors. I assume by the word at least you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture is a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury but not for this court.
Well, he's implying there's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right. this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring up
question can be rephrased.
exhibit Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go, I'm just trying to weigh whether we should take a break.
I will probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories, and additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework, and additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes,
And at the time you did the testing in this case, did you satisfy those standards?
yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report, and this is, it looks like report number, or exhibit number 30, if we can pull that up, just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. you just list off the areas of that firearm where there was evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question, in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, I'm sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired. Cartridge case has been fired.
Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown, unrelated individual than if they originated from 2 unknown, unrelated individuals.
And did you make a conclusion here as well about a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing. It has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called a random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person, can't state it's infallible, can't state there's a zero error rate, and you can't state that it is a source connected with any one person, correct?
Right, so part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you, that's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused. All right. Thank you, ma'am. You may step down. Anything further from the defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you. All right, do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling. And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right. In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff Nyman, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we...
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right. Nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as have it switched to audio only to the state. Now, my understanding, there's no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And to the stage, just let me know if you're ready. Let's go ahead and play it now. that concludes the playing of State Exhibit 12.1. Video transmission may resume. Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
And Your Honor.